You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 414 and the dictation speed is 100 words per minute. Ready? Start. The appellants are accused numbers 1, 3, 6 and 7 respectively. The appellants have been convicted for the offences punishable under section 302 read with section 149 of the Indian Penal Code. The allegation against the appellants is of committing culpable homicide amounting to the murder of one Aslam Khan. The incident is of 3rd February 2013. There were 8 accused who were tried for the offense. Out of the 8 accused, the trial court convicted 5. One died during the pendency of the trial. An appeal against conviction was preferred before the High Court. By the impugned judgment, the High Court confirmed the appellant's conviction. However, the High Court set aside the conviction of accused number 5. The case of the prosecution is that accused number 1 picked up the victim of the offense from his residence at 4 p.m. on the date of the incident and took him to Raja Bazar. The accused killed the victim behind LP school by assaulting him with a sharp weapon. Learned senior counsel appearing for the appellants has taken us through the notes of evidence of the material prosecution witnesses. He pointed out that in paragraph 42 of its judgment, the trial court held that the claim of PW1 that he was an eyewitness was fallacious. He pointed out that even evidence of PW3 needs to be discarded as his evidence is full of omissions and contradictions. Moreover, he cannot be termed an eyewitness. As far as evidence of PW4 is concerned, he again submitted that the evidence is not worthy of acceptance as it is wholly unreliable. He pointed out that evidence of PW6 shows that there was a prior enmity between her husband and the accused. He pointed out that PW6 admitted that her husband had lodged a police complaint against the accused on the allegation that the accused had dispossessed him from his land. He submitted that evidence of last seen together in the form of testimony of PW7 cannot be relied upon. He submitted that the same is true with evidence of PW9. He pointed out that evidence of PW10 does not help the prosecution at all. He also invited our attention to the evidence of PW11. He submitted that while recording the cross examination of the prosecution witnesses, the contradictions had not been properly recorded in accordance with the law. Learned senior counsel appearing for the state submitted that the evidence of prosecution witnesses shows that the deceased was last seen together with the accused. He submitted that coupled with the evidence of last seen together, the motive for the commission of offense had been established. Even otherwise, there is convincing evidence against the appellants. He therefore submitted that no fault can be found with the view taken by the High Court. There is one aspect that was not brought to the notice of this court, which goes to the root of the matter, as can be seen from paragraph 108 of the judgment of the trial court. The appellants have been convicted for the offense punishable under section 302 with the aid of section 149 of IPC. We may note here that ultimately the High Court held that only four accused were guilty. Under Section 149 of IPC, every member of an unlawful assembly is guilty of the offences committed in the prosecution of the common object of the unlawful assembly. Therefore, to apply Section 149 of IPC, there has to be an unlawful assembly. Section 141 of IPC defines unlawful assembly as an assembly of five or more persons. The High Court has not held that, apart from the present appellants whose conviction was confirmed, others formed part of the unlawful assembly. Hence, there was no unlawful assembly within the meaning of Section 141 of IPC. Therefore, the appellants could not have been convicted for the offence punishable under Section 302 of IPC with the aid of Section 149. The High Court has not modified the charge from Section 302 read with Section 149 of IPC to Section 302 read with Section 34 of IPC. Before we deal with the merits, something must be stated about how the trial court recorded the prosecution witnesses' cross examination in this case, especially when they were confronted with their prior statements. The trial court did not follow the correct procedure while recording the contradictions. Under Section 161 of the Code of Criminal Procedure 1973, the police have the power to record statements of the witnesses during the investigation. Section 162 of Code of Criminal Procedure deals with the use of such statements in evidence. The basic principle incorporated in subsection bracket 1 of section 162 is that any statement made by a person to a police officer in the course of investigation, which is reduced in writing, cannot be used for any purpose except as provided in section 162. The first exception incorporated in subsection bracket 2 is of the statements covered by clause bracket 1 of section 32 of the Indian Evidence Act 1872. Thus, what is provided in subsection bracket 1 of section 162 does not apply to a dying declaration. The second exception to the general rule provided in subsection bracket 1 of section 162 is that the accused can use the statement to contradict the witness in the manner provided by section 145 of the Evidence Act. Even the prosecution can use the statement to contradict a witness in the manner provided in section 145 of the Evidence Act with the prior permission of the court. The prosecution normally takes recourse to this provision when its witness does not support the prosecution case. There is one important condition for using the prior statement for contradiction. The condition is that the part of the statement used for contradiction must be duly proved. When the two statements cannot stand together, they become contradictory statements. When a witness makes a statement in his evidence before the court which is inconsistent with what he has stated in his statement recorded by the police, there is a contradiction. When a prosecution witness whose statement under section 161 bracket 1 or section 164 of CRPC has been recorded states factual aspects before the court which he has not stated in his prior statement recorded under section 161 bracket 1 or section 164 of CRPC, it is said that there is an omission.